What about this petition from Professor Kwaku Asare to the President for the removal of the Chief Justice, Gertrude Araba Esaba Tokono? And the President says, together with the Council of State, they have made a determination, prima facie, as required by the law, to look on the face of the document that, in fact, if it has any substance, and they have come to the conclusion that it is frivolous, it is vexatious, and it doesn't have any merit. So they've thrown it out. Justice Sophia Akuffo, former CJ, doesn't think that our constitution actually is made in a way that gives us room to be able to deal with impeachments like this one the way it ought to be. Listen to her.
In just the last few days before the expiration of his term, during President Akufo-Addo's tenure, we had a professor of law, for instance, Professor Kwaku Asare, then asking for the removal of the Chief Justice.
It's not even, let's not even use the word removal, because you need to do, before you reach removal, you're going to go through an impeachment process, which must be, whereby you must follow the dictates of the Constitution. Now, personally, I don't think the provisions of the Constitution are adequate for the purpose of impeachment of anybody. In the current arrangement, you petition the President, and in the case of the Chief Justice, the matter is referred to the Council of State, which has to go through certain processes. And it's not just a question of, I want to remove this person, and then it goes to Council of State, and then Council of State comes back and says, yeah, we agree with you, go ahead and do it. There has to be due process. Even in the lower court, there are processes that must be followed. But so you can send in your petition. It's not just by an appeal to the President or whatever. You need to send a petition, and the petition must set out some reason. That's part of what due process is all about. So if I'm not in the country, and I've not really been following that aspect of the matter. I know that such a call has been made, but I'm yet to know what the justifications are that the petitioner has given for asking the removal of the Chief Justice. But right. It's not that easy, even under the Constitution as it is now.
Right, so let me begin with Oliver. So in the President's prima facie determination, among others, some have condemned it and criticized it as half assessment, that it didn't do a good job with it, and that there is obvious prejudice from the very start. At least you begin with, from page 1, you hear about leakage and why all of that is bad. And Professor Kwaku Asare is referred to as a self-acclaimed advocate for good governance, who is interested in resorting to public theatrics. And actually, there was an expectation of an apology for leakage of the petition. So they make a conclusive statement that he who brought the petition leaked it, and so on. Let's hear your assessment of the prima facie determination.
Yeah, thank you for that. Before I go into the substance of the determination itself, I want to make a quick comment about what I see to be some sort of inconsistent practice and procedure around the issue of the prima facie case itself. So we know that generally in law, the prima facie case ought to be established on the basis of what you have presented only, right? But the practice for the removal of other justices and other officials, I call them generally Article 146 officials, is that the Chief Justice has taken the position to ask them to submit a response to them. And so that's where you usually have the right to the people and ask them to send a response.
I can confirm that because I have done that process before. And when my client, we submitted our petition for the removal of Charlotte for Loretta Lamte.
Loretta Lamte.
Yeah.
Now there are two.
The Loretta Lamte was asked to present her response. In Kisie Jaben's matter, he was asked to present a response. In Charlotte and the others, they were asked to present responses. Yeah.
And let's make two distinctions. So there's the Article 1464 process,
right,
which applies to everybody else under the article, and the 1466, which applies to the Chief Justice. Now, the Supreme Court told us that under 1464, there's a prima facie requirement that is written into the Constitution, and that we should apply same to 1466. But when it comes to how we have operationalized the removal of the Chief Justice, the presidency at no point called on the Chief Justice to present a response to the petition that has been filed. So there's some inconsistencies in practice and procedure within that article itself that ought to be looked at. Secondly, the biggest challenge I've had from time and time again is that we have seen, and I think you've made allusion to this in the past, almost all presidents under the Fourth Republic either refuse to forward petitions or undertake that prima facie assessment.
That's right.
And it is these situations that have created, perhaps in certain petitioners, a desire to elicit the public support and putting pressure on the office to do what is constitutionally required. Now, obviously, I have disagreed with the idea of publishing the content of the petition, but I take the point that the law is that you don't publish it. But I'm also a bit challenged as to now we are stretching it to say that even the fact that the petition has been made should not be disclosed. It shouldn't be known to the public.
But publishing it does not defeat the substance of the petition. The court also says so.
Yes.
Right.
Now, the courts have taken that view more generally. Now, let's go to the president's response. First of all, and you've pointed out in the beginning, I am dismayed by the absence of a maturity of tone in the way in which the exercise is supposed to be conducted. It was completely improper for the presidency to dissolve into a process where they are calling the petitioner names. I think that is uncalled for. Unfortunately, we had seen that tone of communication from the presidency, even in the case of Domelevo, for instance, where aspersions was cast on his person, was called the Togolese. It was just a combative nature in the way in which the communications were made. I think that the prima facie determination is a sober process that requires that neither the president or the Council of State descend into the arena of conflict by some of the things that were said. So the aspersions cast on the petitioner are unfortunate. There was absolutely no basis to call him so-called advocate at some point purporting to represent good governance. It's the language they used. Or even the accusation that he leaked the petition. I feel, at the very least, if you feel constrained by that you write to the petitioner and say that we have seen this in the public domain, if you are so certain that this leak did not come from the presidency, and to offer the petitioner a chance to comment, to write that the petitioner should have sent you an apology, and that the failure to send the president an apology, I honestly, really did not think that for something that history would look back on, that kind of language should have found its way into it. But there are a number of analysis that was done here that I don't think necessarily is consistent with law. One, on the question, for instance, that the petition, one of the aspects of the petition was that the Chief Justice placed the hearing of cases involving some parties before the same High Court in the dispute, I think, Daniel Oforian and Ecobank. The conclusion, it seems, was that it is within the president's, the Chief Justice's administrative remit to do so, and for which reason it cannot be questioned. But we know clearly that in the J-Chum, for the decision, the Supreme Court decision in J-Chum, that this issue came up. That in that case, the allegation had been that the then Chief Justice had instructed 3 Circuit Court justices, Opon, Antama, and Chairman, to rule a certain way. And it was argued to the court that the Chief Justice was performing an administrative function and could not be questioned. And Justice Dateban said absolutely not. That the fact that this was the case cannot be an issue. But also importantly, the presidency says the judges that Professor Asari was referring to or the victims in that case have a remedy in law. And so they could have they could have appealed or done other things. In Ajay, the truth was clear that the fact that an alleged victim of an administrative act of the Chief Justice would have a remedy does not mean that, or is not a substitute for a procedure for making the Chief Justice accountable for the performance of their duty as Chief Justice. So it cannot be a basis to say that Professor Asare was not himself involved in it, and those who were affected by it could themselves have found other remedies. The law is clear on that. Now, reading the response, one of the things that I struggled with is what is the exact legal standard that was being applied to judge the petition. So in one breath, the presidency says the prima facie determination requires that the president takes all the allegations as true and proceed from there. It would seem that if you're taking it as true, the conclusion would be, if it is true, would it still lead to proof of incompetence or stated misbehavior? But that's not what they do. They abandon that truth point and in fact go on and attack the petition as being a collection of conjectures and that the statement that he has produced were factually untrue. Then it means that you're going beyond the standard and you're doing the work which is reserved from the committee to evaluate evidence. So that's one of the things that I find.
You are suggesting that the prima facie determination did the job that the actual committee that would have done the inquiry did. Is that what you are suggesting?
Yes. So the inquiry goes into the weighting of evidence. It is not the presidency's role to do that. If you are taking something as true, the conclusion would be, if taken as true, would these facts as true lead to a conclusion that the Chief Justice has been incompetent or has misbehaved? I do not know how. Again, I am not going to speculate as to what the committee should do, but I do not know how an allegation that the Chief Justice was involved in transferring and changing judges and moving them at will and at displeasure because she wanted to influence the outcome of those cases, if taken as true, can lead us to a conclusion that that's not misbehavior.
But they said that. But they said that the president says, yes, prima facie, they are supposed to look at what is being presented to them on the face, but there is also the need to have attached some evidence. And Prof didn't attach even one simple evidence to help them do their work. So the president then took time where Professor Asare spoke about matters that he didn't have evidence to show. The president then took time to explain to Professor Asare. For example, in the question of the nomination of the judges, extra judges for the processes of bringing them to the Supreme Court, the president took Professor Asare through the process, how these had gone on in a transparent manner and so on. But Prof came without any evidence. But the president had the evidence that this is the process that went on and the Chief Justice did nothing wrong.
So I would make a brief comment on that particular issue and I'll come to the larger question of evidence, okay? So on this particular issue, this is one of the reasons why if the presidency had proceeded with the benefit of a response from the Chief Justice, they would be better placed to take that response for what the Chief Justice says. Here you are descending into the arena of conflict by providing explanation on behalf of the individual. And that explanation, I'm not even entirely convinced, satisfies the issues that have been raised. One, the letter the Chief Justice wrote to the presidency said to the president that these are the individuals I am presenting to you to nominate to the Supreme Court. The presidency said, I only asked the Chief Justice for a brief of some discussion that had happened. There was no summary of a report. There was nothing in that letter that shows that it was a feedback on some process that had happened. But we are substituting your own response here for the Chief Justices. And if that's the case, the Chief Justice is competent to be able to say exactly why the Chief Justice wrote that letter. And I'll come to the broader question of that letter itself subsequently. On the question of evidence, and this is some of the things I want us to talk a bit about, because something you have written an extensive guide on Article 146 process. And one of the things I loved about that guide was that you talked about the inquisitorial process itself. One of the key takeaways for me here is that it seems that at the prima facie hurdle, we have an adversarial process. And then later this will dissolve into an inquisitorial process. My concern then is the inconsistency in this. Because what we do, we know with an adversarial process is that it can discount the likelihood that the evidence that may be necessary can only be elicited under subpoena. And in fact, when you read the petition, the petitioner says that there are certain justices who will be subpoenaed. 2, that the person whose character is being impugned may hold evidence which is crucial to the assessment of their misconduct. You cannot produce that at the petition stage. And if you are being required to do so now, then no petition will progress to the later stages. And if you haven't been involved in the process, you know then that in that process, there's the petition for witness statement, there's cross-examination. That's when evidence is examined. So if you are bringing that, you are front-loading that process now, you are creating an impossible task where critical issues will not be addressed. So even buttress this point, if you remember the decision in the J2, and perhaps I want to quote here, what's the reasons why the Supreme Court felt fortified in saying that there must be a prima facie determination is because it agreed with the second defendant who made this point, and I'll quote, it said, it would be the height of naivety to assume that the president in popular parlance just got up and set up a committee without satisfying himself that there's a prima facie case against the Chief Justice. The president is a lawyer of over 30 years standing at the bar. He knows and understands the essence of a prima facie case. And to satisfy himself, the president has competent and well-established national investigative institutions capable of assisting him to satisfy himself, to satisfy the Council of State, and that the allegations establish a prima facie case. The president has the BN9, the police, the Serious Fraud Office, the National Security, Military Intelligence, and the Attorney General's Office to help him establish a prima facie case before deciding to establish the Committee of Inquiry. It seemed to me the suggestion here is that the Supreme Court was also extending that need for an inquisitorial process to this level. And so, therefore, if the president has received information that the Chief Justice has done X, Y, Z, if you had received a response from the Chief Justice as to the reasons, if you felt inclined to go even into reasons, you would then have been satisfied or otherwise. But I'm worried that we will create an impossible standard at the barrier here, which it will become convenient for presidents to not do assessment that is required or do more than is required, for which reason we discount.
I'm sorry, but for lack of time, I need to come to the studio here. If you can, in the next minute, wrap up for us and tell us, so it's over. I mean, this one too is gone.
What do you mean this one too is gone?
Like it's over, like the prisoner pardon letter.
Well, I mean, I to be honest, one petition doesn't.
I should have said it is finished.
The accountability standards to which we hold the Chief Justice going forward. I mean, that has to be clear. But I am more concerned about due process, whether it has been. I don't think it has. But I want to make one last comment on this, even this issue of this letter issue, which I reserve for the last. When the president has determined that prima facie case has not been made, it is not conclusive of how we, the general public, morally assess the Chief Justice's conduct and its impact on the esteem of the judiciary. For instance, I do not think it should be considered proper that a Chief Justice will place himself in a perilous position of writing directly to the president to ask for certain judicial colleagues to be appointed to the Supreme Court. I consider this to be gravely improper and lacking good judgment. In fact, one of the things it does is that it undermines the central authority of the Judicial Council. Secondly, the question of court packing is a deeply contentious issue.
That's on the presumption that the CJ is doing it without, the Judicial Council's input. Well, the
Judicial Council is a
CJ chairs the Judicial Council,
right? And so, when the Chief Justice is writing, she's writing with the authority of her office as Chief Justice, and everything she does cannot be assumed to be the act of the Judicial Council.
All right. I'm sorry, but I need to move on here into the studio. And please forgive me about that. Time was running and we didn't pay attention. Yes, Prof, what do you make of the prima facie determination and end of the road for the petitioner, isn't it?
The Constitution doesn't even mention the expression prima facie. The Supreme Court, as Oliver said, has inserted that. But there's a reason for that. And the reason, I think, is because of the enormity of any allegation against the office of the Chief Justice. The Chief Justice's office is an office which is heavily steeped in perceptual efficiency. If people don't perceive it in a good light. It affects the overall administration of justice. So the expectation is that we shouldn't allow rampant and, so to speak, fallacious allegations against the Chief Justice to just be taken seriously and go through the investigative process. I suspect that's why the Supreme Court inserted the expression as a mandatory requirement of Article 1466. But having said that, I do think, and again I see Oliver's point of perspective, the presidency has the panoply of investigative bodies. I don't even think, and I do not agree with that part of what he said in terms of the fact that the president could have invited the Chief Justice to respond. I don't think in the determination of prima facie cases, a response usually is necessary.
But they have always demanded a response
right,
from the CJ when she has to determine prima facie
right,
before a committee is set up.
Right, and that's what I'm saying. I don't think it's necessary.
All right.
Because the determination of a prima facie case, usually in law, is a determination of a factual basis to an allegation. In fact, in the case of Kwache and Attorney General, that's what the court said. That look, if you make allegations of, if you make allegation on the existence or otherwise of a fact, you have to provide a factual basis to your allegation. So if, for example, the president has the BNI and the police service, the intelligence bodies and all that, and there's a way of doing background check to ascertain the veracity, the facial veracity, it's facial, that's why it's facie. Prima facie, that's primary fact, the basis, the facial justification for an allegation. Once we come to a conclusion that there appears to be a basis for the allegation, a prima facie case has or may have been established. So even the Chief Justice being called upon to write may not be necessary. And the reason I think it may not be necessary is because the process invariably will involve the Chief Justice having to appear and give evidence. So burdening her at the early stage of any, with all respect, and I'm not saying Tom, Dick, Harry to this particular petition, but I'm just saying the expression, to any Tom, Dick, and Harry making an allegation, expecting that every time the Chief Justice should be called upon to give a response, it's unnecessarily burdensome to that office, which is very busy doing all kinds of things for purposes of administration.
So you take the view from Oliver that the process is inquisitorial and not adversarial. So those that receive the process must not expect that it is the one who is making the accusation or the one to whom the accusation is against. They are the ones to litigate, but they must take the steps to confirm things for themselves.
But that's just a fact. It's just the fact of investigations. Investigations are always inquisitorial. They are not adversarial. Adversarial is judicial, but are judicial, not continental. But inquisitorial are investigations are fundamentally inquisitorial. And the reason there is because the investigative body or entity is interested in the truth. It is not interested in the evidence.
Fact finding.
So what it means is that you may not even have the evidence, but it may go for the evidence itself.
Right. So I ask it because, he mentions that I have written about this. I wrote it on the back of the fact that when I was prosecuting my case for the impeachment, we were tendering evidence that it was difficult, but we still got the evidence. And they were trying to, the lawyers for the one being petitioned, the respondent, were impeaching our evidence and asking that we didn't get it from proper custody, so it should be thrown away. And sometimes they were agreeing. So I had to insist to the committee that you are doing an inquisition. So you shouldn't expect me to provide the evidence. You, in fact, should go out there and fetch the evidence.
Our lawyers are not trained in the skill and arts of inquisitorial proceedings. Our lawyers in Ghana are fundamentally trained as adversarial lawyers. So occasionally when they interface with the inquisitorial regime, they are confused. And I'll give the example of SHRAJ as one. SHRAJ is an inquisitorial body. SHRAJ is not established to just be a neutral hearer of evidence and to decide whether a party wins or falls on his own case. However, the lawyers who appear before SHRAJ have been trained in only one skill, and that skill is adversarial. And so they bring the adversarial orientation to the inquisitorial body, and unfortunately, sometimes the inquisitorial chair people themselves are not able to direct proceedings.
So you don't think the presidency has done a good job, and is the end of the road for Prof?
No, I think on this particular matter, the presidency should have established a prima facie case. The problem is the determination of a prima facie case is fundamentally subjective. It's not, in other words, the president will have to come to a conclusion that it has established a prima facie case.
This petition should have passed the threshold of a prima facie.
It has to. That's what the law. That's what the Supreme Court together has.
So now that they say it doesn't, what should the petitioner do?
Well, the petitioner must always have the liberty of repetitioning. Yeah. But this petition is gone. It has been determined that the petition doesn't meet the threshold of a prima facie case. And that's it. Whether you agree or not with the assessment is not the issue. It's gone. You can't appeal against it.
There's no room to a court?
No, you can't appeal. The court
I have just a minute left.
The court cannot second guess.
Let's hear from you.
Oh, I think that I'll just take you from where Prof has left off. I mean, this is it for this particular one. The gate is shut completely. And I believe that Prof certainly has every opportunity to repeat his petition. You know, look, there are many coincidences that have come to play. There are also ethics within which the Chief Justice is supposed to operate. And I believe that these things have happened way too many times. So indeed, what the contents of that petitioner actually put before the president are matters that we have all been complaining about. You look at the CDD report, you look at the Afrobarometer report, you look at perceptions of the judiciary and how they work and everything. And even look at recently what happened even in the Supreme Court when this matter of the speaker was before the court. You know, I believe that there's a lot of things that happen that actually completely undermine our faith and trust in the judiciary. And
Joyce Bawa, Kweku Asare, Kofi Abochi, Oliver Bakavamawo, and Rabi Salifu. Thank you all so very much. And of course, Alfred Chiayebwa. My outfit, as always, is by Konati Clothing. Call them 0244-676732. This has been Newsfile. It's your most authoritative news analysis platform. Have a good afternoon.